Hello, this is your second of two videos on the U.S. Constitution. In this one, we're going to talk about the limitations on state powers and the very important doctrine of federalism. We will then talk briefly about separation of powers, and I say briefly because we're going to have an entire week on the presidency, a whole week on bureaucracy, a week on Congress, a week on the courts, so I won't go into the details there, but I am going to talk about what separation of powers is and some of the basics. And then we'll talk about the amendment process. So first, federalism and the Constitution's limits on the powers of the states. You remember that under the Articles of Confederation, the state legislatures were very powerful and there was a weak national government. So, the Articles was a system of strong states and a weak national government, and that is one of the main things that the people who wrote the Constitution intended to change. They wanted a stronger national government, but they wanted to keep the states still with a certain amount of sovereign power. In other words, they were still going to be functional governments. They were going to have an important role, but they weren't going to be as powerful as they were. So the Constitution limits the functions of states in a number of very specific ways and sets out a whole new relationship between the national government and the states. And we call this a system that has two levels of government. We call that federalism. And we'll talk more about that. Let's go into it. A federal form of government, like what we have, is one in which the governing power, the power to govern the country, is actually shared between a national or central government and some kind of territorial subdivisions. They could be states or they could be provinces, but some kind of territorial subdivisions. And these power relationships really have to be described in a constitution. They could be, and if they're not, it's very complicated to try to administer a system of federalism because you really need written constitutional provisions that you can read and interpret, or else you can have all kinds of conflict over what the national government can and can't do and what the state or provincial governments can and can't do. Now understand that in almost all federal nations, including ours, the subdivisions came first. In other words, in this country, the states came first. We had states before we had a national government. And that means the states do not derive their right to exist from the national government or the U.S. Constitution. They pre-existed the Constitution. We had states before we had a Constitution. We had states before we had a national government. And both the national and the subdivisional governments, in our case the state governments, have direct links, direct connections to people. Now, as opposed to what? Well, there's two alternatives. One would be a unitary government where all the power emanates from the central or national government, and the subdivisions are basically just subunits. They're just administrative subunits of a central government. They are not autonomous governments that have their own power and their own connections to the people. That would be what's called a unitary government. And that is a very common way to run a country. France, China, many big nations around the world are unitary governments where all the main power emanates from the national capital. And the subdivisions are there to administer national policies. In many cases, the subdivisions were actually created by, or they exist at the pleasure of the national government. That's not the system we have, clearly, but many countries have that. And the other end of the spectrum is a confederation. That is an extreme form of federalism in which almost all the power is in the hands of the territorial subdivisions. Now that would be the U.S. under the Articles of Confederation, or the Confederacy, the Confederate States of America during the Civil War, or the United Nations. A confederation is basically a union of sovereign nation states, in essence. Now, so we started off on this continuum way over on the left as a confederation, and then we moved more with the Constitution and other events more toward being a federal system, which is what we are. But we have never moved toward being a unitary state where the national government has all the power, like China, France, Italy. So we're not like that. Now, what is good or bad about federalism? Well, here's the good part. It is good for multicultural nations. It is good for nations that have a lot of different parts of the country, regions, areas that have different kinds of populations. Maybe people speak different languages. They are predominantly from different racial groups, religions, etc. And so if you have a multicultural nation, you can kind of avoid civil war and endless conflict by letting the states or the provinces kind of do their own thing in a number of policy areas and do what the people in their state want them to do. So you don't have one rule for the whole country in certain policy areas. It also lets you preserve local identity, linguistic identity, for example, religious identities, that sort of thing. And another advantage is that it allows the citizens multiple points of access to the political system. We have that. If you don't get what you want from the national government, well, maybe you can get it from your state government. In theory, some political scientists say it offers a protection against authoritarian government because you have so many different governments. It's very hard for a national government to control everyone. That's debatable, but some say that. On the other hand, federalism is very cumbersome, particularly if you have a nation with homogeneous populations. It is complicated. Endless reconfiguration and discussion and amendment and lawsuits and tinkering, and sometimes very slow decision making because you make a change in national policy and then you have to make it in a whole bunch of different states, and then there can be a lot of disputes, and we have had a lot of disputes over whether we would have one uniform rule across the country or a lot of different rules. Even things like policy regarding the COVID pandemic, and obviously the number one failure of our system of federalism was the Civil War that resulted from the conflict over slavery, where the southern states would not accept the abolition of slavery, which had not happened yet, but even when they thought it might happen, they seceded from the Union and there was a civil war. How common is federalism? Well, we have about 193 nations, maybe a few more, in the world. Only about 25 of them have systems of federalism. However, it's 40% of the world's population, and if you look at them, they include some of the most important, powerful, and populated nations in the world, and some of the best and strongest economic systems, such as Argentina, Australia, Austria, Belgium, Brazil, Canada, Germany, India, obviously an enormous nation, Mexico, and on, and the USA. Unitary systems, as I said, China, France, Japan, Italy, the UK, Cuba. Obviously, China's an enormous country with a unitary system. So it's a minority of the nations and less than 50% of the population, but a lot. Now, to understand federalism, first you've got to get clear on the Supremacy Clause. Article 6, paragraph 2. This Constitution and the laws of the U.S. shall be the supreme law of the land, and the judges in every state shall be bound thereby. So, national law is supreme if it is in compliance with the Constitution. Now, if it's declared unconstitutional, of course, that's a different story. Then it's invalidated. But laws made that are constitutional by Congress are the supreme law of the land. And state laws that are in conflict with a legitimate federal law are invalidated. So that's one important provision that limits the powers of states. Then I mentioned a number of other things, but that we can get to in a minute. But let's jump. Stay with Article 10. Article 1, Section 10. This is where the states were put out of certain type of governing business that they were doing. No state can enter into any treaty or confederation. You see, the states prior to the Constitution were engaging in their own foreign policy, and they were trying to make treaties. So you'd have a treaty of South Carolina with France, and then Virginia might make a treaty with the UK, this sort of thing. Well, that has to stop. Section 10 says no, they can't do that anymore. They also cannot do other things. They cannot, you can read them, but note that they cannot impair the obligation of contracts. This goes back to that notion of the elites again. States were passing laws that were invalidating certain types of contracts. And so in people who were, let's say, owed money, like a banker, would suddenly discover they weren't going to get that money because the state legislature passed a law saying people didn't have to pay them back because of the nature of the contract that they wrote. Maybe the interest rate was too high. And the state said, well, if the interest rate is above 8%, you're not going to get paid back. In other words, they were impairing the obligations or blocking the enforcement of contracts that had already been entered into. Well, that's all. The states can't do that anymore. Contracts are supreme. And you can see on and on. They can't tax imports and exports and so forth. They engage in war, blah, blah, and so forth. So states are put out of certain type of business they've been engaging in. Now we have another series of provisions here. The full faith and credit clause. This we're going to go through, more of this in a bit more detail, but essentially, the idea here is that the full faith and credit clause requires that the states recognize the laws and the judicial findings that happen in other states. The reason they had to do this is because some states were saying, well, we don't care what law they passed in Virginia. We're the state of Pennsylvania. We don't have to acknowledge what they do in that state. Well, yes, they actually do. Now, why has this become important? Well, imagine like today, if you had a driver's license and issued by Illinois, and you drove into Indiana, and they said, oh, no, you can't drive in Indiana. You don't have an Indiana driver's license. Or let's say you own a piece of property here in the state of Illinois, and it's yours, you have the deed, and the state of Indiana refuses to acknowledge that you own that property, and instead they say, well, we don't recognize Illinois deeds, we're going to give that property to someone else. See, this wouldn't work, would it? Or you get married in one state, and they say in another state you're not married. Or you get divorced, and they say in another state, we don't like divorce, so you can't be divorced. So it would cause all kinds of problems. Now, I said that they awarded the national government this special status, the Supremacy Clause. However, the 10th Amendment is still there. And in the 10th Amendment, which we went over, protects the states to a substantial extent. In other words, it says that, remember, the federal government has only the powers that it is given, and the states have all the other powers they call the reserve powers, the police power. So what that means is, despite the fact that federal law is supreme, it's only the laws that are actually written in the Constitution, the laws that are passed legitimately by Congress pursuant to a specific authorization in the Constitution. In everything else, the states remain, as we say, first in time and first in right. So the Constitution says the federal government is supreme in its own defined realm, but outside that, the states are still the sovereign power. Now, we can break down the history of federalism in this country into eras or time frames, stages, because it hasn't all been the same. It has evolved over time. Our system of federalism, the way the states and the federal government interact today is not the way they interacted back in the early days. So the first era would be the Confederal era, 1775, the start of the country through 1788. The Constitution goes into effect. Strong states and a weak national government. That's it. Then, the system that we're going to talk about briefly here is dual federalism, 1788 to 1933, where the country was sometimes seen as being like a layer cake. Federal government on the top, state layer below it. Separate layers doing different things. 1788 through the Civil War, the conflicts over slavery were the main problem, and that really brought the whole federal system down in ruin, and the country basically fell apart and collapsed into two separate nations that were fighting with each other and killing each other by the hundreds of thousands. And we remade the system. Now, we're still in a system of dual federalism, but from the Civil War through 1933, we have a second stage of dual federalism, which is a more powerful national government that is working increasingly with a growing national corporate economy. And what changed it was first the Civil War itself, the fact that the South just lost. And second, the amendments to the Constitution, 13, 14, and 15, that changed the nature of the relationship between the national government and the states. The 13th Amendment abolished slavery, and the very important 14th Amendment contained a number of provisions that we will be talking about in considerable detail, but they basically required the states, all the states, to respect the rights and privileges of American citizenship. We're all citizens. Everyone born or naturalized in the U.S. is a citizen, and that we all have certain rights that go with being a citizen of the United States, and no state can interfere with that. Up until that time, states had argued, well, we get to define who's a citizen of our state, and we can define what their rights are. No, it doesn't work that way. No state can interfere with the rights of national citizenship. From 1933 to the present, we call it cooperative federalism, where through the use of money and other provisions, the national government and the state government have supposedly been trying to cooperate to a greater extent to accomplish the same objectives. Like, for example, during the time of COVID, you see the national government and the state governments, in most cases, trying to cooperate to deal with the pandemic. That'd be an example. Or natural disasters. Something goes wrong, a hurricane. The federal government steps in to try to help the state government. This is the model. It doesn't always work, but that's the idea. And then from 1981 to the present, there's been a lot of conflict over this. Republicans particularly have pushed back against the idea of cooperative federalism and tried to restore the notion of states' rights. So there, if you just put it in order, that's what it looks like in a diagram as we go through the history of the country. Now, this old system that I just talked about here, this system of dual federalism that we had, say, from the founding of the Constitution through the from the up until 1933, what we have is two separate spheres of power, where each level of, that's the model. Now, it was a lot of conflict over this, but the idea was each level of government, it's kind of like a separation of powers, or a separation of duties, where they try to not step on each other's toes. The federal government is trying to do only what it has been told to do by the Constitution, and the states are doing the police powers. That was the model until 1933 and the New Deal, but it failed during the Civil War, had to be reconstituted, and a great example of how it worked was Barron versus Baltimore. What you see here is a map of Baltimore Harbor from the 1930s. This is just an example of what we meant by dual federalism. So there was a man named John Barron, and he owned a wharf, Barron's Wharf. The city of Baltimore was doing a lot of construction. They dumped a whole lot of dirt in the harbor, and it silted up the harbor so that the ships could not get to his wharf anymore. They ruined his whole business, made his wharf valueless. So he sued the city of Baltimore, which is viewed as in essence, an agent or an outgrowth of the state of Maryland. That's the way we view cities, that they are, in essence, operate under state authority. So he sued to recover under the Fifth Amendment Takings Clause, which says, remember Fifth Amendment, and remember this notion of the federal government being the target of the Bill of Rights, right? Fifth Amendment says, nor shall private property be taken for public use without just compensation. So he says, you've taken my property and you have to compensate me. And in the trial court, he won. But the Supreme Court reversed. They said, no, you get nothing. Why? The Fifth Amendment has no bearing on the actions of state governments. In this case, a city, which is an agent of the state. It only limits the national government. That's the classic dual federalism. You know, we have the same Constitution, but the constitutional protections in the Bill of Rights only limited the national government. Now, that is not the system anymore, because now, you know, that's all been changed. But that's the old system of dual federalism. The failure of dual federalism really is what led to the Civil War. the famous or infamous Dred Scott case. Dred Scott was a slave who had been taken to free states and territories for years. He tried to buy his freedom. He was refused. He sued to get his freedom. It's a long story, but the U.S. Supreme Court ruled against him. They argued that he really didn't have any rights, and they caused the conflict over slavery to explode the entire federal system. They said, and this is a quotation from the opinion, and I'm not going to actually read all this, but the quoted language in there comes directly out of the opinion of the Dred Scott case, and they said that because he had been an enslaved person, he could not become a member of the political community of the United States, no matter what state he went to. The fact that he had gone and lived in so-called free states, it didn't matter. The Constitution did not protect him at all, and he had no rights. And this was, again, we've talked about this in the first video, but this, again, is one of the most shameful episodes in the history of the U.S. Supreme Court, where they said that the African-American population basically had no rights. It's kind of an unbelievable thing. And they also said that state legislatures did not have the power to ban slavery within their own borders, and that Congress did not have the power to deprive this, quote, slave owners of what they claimed to be their property, human beings. Because, the core of this opinion had to do with the idea that there were slave states and free states, and the Supreme Court saying, well, what do you mean free states? Congress can't ban slavery anywhere. So they declared the Missouri Compromise, which had said that some states were going to come in as free states and others as slave states, was unconstitutional. So that meant that Congress could not even regulate the political conflict over new territories coming into the Union, like California and others. All these new states coming in, Congress could not regulate the political conflict over how many slave states or how many free states there would be. Potentially slavery could be everywhere, because they're arguing that the African American population had no rights. You see why I say it's a disgraceful decision. Well, we know where this led. This led to a civil war, because suddenly there was a political conflict that could not be resolved by the courts or even by legislation. And so there was a terrible war in which over 600,000 Americans died. But the war resolved certain things, and so did the post-war amendments. The idea, the nullification doctrine, the idea that states could nullify federal laws, well, that was done away with. No, they can't. The 13th Amendment abolished slavery. The 14th Amendment created national birthright citizenship, with rights that no state can interfere with: due process of law, equal protection of the law, privileges and immunities of citizenship. And the 15th Amendment guaranteed the right to vote. But it took a long time for the Supreme Court to admit what that really was, because southern states and border states tried to maintain, they did in fact maintain segregation and racial discrimination for a very long time, really up until the 1950s and even into the 60s, despite what the clear language of the 14th Amendment. Now, there were more amendments that happened. I won't go into all the details, but the Progressive era, say, 1980 through 1920, 1880 through 1920, 1880 through 1920, the Progressive era. The 16th Amendment created the income tax. The 17th Amendment gave us direct election of senators, so we didn't have to have our senators chosen for us by our state legislatures. All these amendments, the Civil War amendments and these amendments, strengthened the national government. They moved us a little bit further to the right along that continuum I showed you. We've never become a unitary government, but the national government got stronger and stronger, and states had to respect the rights of national citizenship. The national government had the income tax, and we had direct election of senators. So this made it possible for the national government to regulate the growing economy. But again, there was a lot of resistance to this. In this case, the Supreme Court stood in the way. Congress tried to regulate these big, huge emerging corporations, railroad corporations, steel, oil, etc. You don't have to, memorize all of this, but understand the Supreme Court stood in the way of Congress regulating the booming, growing industrial economy of the United States. Most state legislatures weren't able to do it. It led to the rise of the robber barons, these fabulously wealthy people of the late 1800s, and the abuse of working people, the creation of monopolies, in a very unstable and volatile economy that went through crazy boom and bust economies. And this is what ended in the Great Depression, 1929, and ultimately the election of Franklin Roosevelt in 1932 and the rise of a new type of federalism we call it cooperative federalism, where we had a stronger national government that offered more financial inducements to state governments to cooperate with the federal government to accomplish major objectives: clean air, clean water, electrification of the South that didn't even, much of which did not even have electricity in the 1930s, running water and this sort of thing, to try to really improve things in the South and elsewhere. And of course, we've seen a lot of pushback against that since 1980, but it still is, I think, the predominant model is a form of cooperative federalism. Some of it is called revenue sharing. That basically is where states are given money back. The national government collects money in the income tax and gives some of it back to states for education, for health. We see that right here at UIC. You know, we get money from the Department of Education, federal grants, federal subsidies of various types. Block grants are where the federal government gives kind of loose guidelines and states can pick the way to accomplish it. Categorical grants are very specific descriptions from the federal government. You must use the following money in exactly this way and no other way. But they're both forms of bringing money back to the states. And then there's this thing called the unfunded mandate. That is where the federal government tells the states to do something and doesn't give them any money to do it. Now that really annoys people. An unfunded mandate would be elections, where, for example, or education, the No Child Left Behind law passed by Congress mandates testing of students. Students have to test, but it doesn't give them money to do the testing with, just as you have to do it. Elections. States run elections for the national office, like the president, but the federal government doesn't pay for the elections. And there are many other such areas. The Homeland Security laws, the USA Patriot Act, require states to prepare emergency plans, civil defense plans, etc., and doesn't give them money to do it with. Now, many of these are legal and they're allowed, but it, of course, generates a lot of resentment. Now, I think let's take just a moment to look at the big picture. The big picture is that many things have happened, and I kind of diagram them here, that have moved the U.S. more in the direction of being more unitary. But we are not a unitary government. We still have strong state governments. It's just that we've moved from those old Confederation days more and more in the direction of a stronger national government and weaker states. Now, Republicans are pushing back against that. They want to make the states stronger again, but I've given you in this slide, you can see all these events that tended to push us in the direction of a somewhat more powerful national government. But there have been other events that have pushed us back. The Bill of Rights limited the national government originally. Nixon and Ford presidents tried to give money to states without any restrictions at all, just take federal money and give it to them to do whatever they wanted with. The Supreme Court has pushed back numerous times on federal and declared federal legislation unconstitutional for infringing on state power. That's happened many times. And so we see an increasing reassertion in a number of states of their own power in resisting federal policies. And it happened with COVID, it's happened with criminal justice, with education policy, and on and on. So, we are not a unitary system. Some events pushed us closer to that pole, but we never got there. And if you had to assess where we are, well, we do see a lot of direct federal legislation in areas that used to be the realm of the states. And we do see the federal government implementing federal policies. Let me give you a couple of examples. Federalism and civil rights. So these are two places that used to, this is back, now we're going back here to the 60s, where there were restaurants and hotels that discriminated against African Americans, wouldn't serve them. Well, the Congress passed civil rights acts, civil rights laws that required them. They required places like Ollie's Barbecue in the heart of Atlanta Motel to serve the African American population on the ground that they were impairing interstate commerce. People literally could not travel between states because of that, they couldn't stay anywhere or eat anywhere. So the Supreme Court ruled that the Congress could do that in some very important cases. And there are many other areas where right now there are debates over the power of the national government with respect to the states. The rights of the LGBTQ population, abortion and other reproductive right decisions, the death penalty, immigration, health care, COVID, the Affordable Care Act. All these things implicate the powers of the state and the national government, and then many things about religion. So we'll always see this dynamic where if one party controls the national government, states that are controlled by the other party will try to go in a different direction and push back against federal policy at the state level. That's an enduring dynamic of our system. So now that's federalism. Let's turn briefly to separation of powers. We're going to have a whole chapter on all the branches of government, so I'm not going to spend a lot of time on this right now except to understand the basic idea. The theory is power has to counteract power. The idea was, when they wrote the Constitution, don't let despotism come into existence. Don't have an overly powerful executive, an overly powerful legislature, or overly powerful courts. Each branch of the government has to have ways of frustrating, blocking the other branches. And why? So that they have to cooperate with each other. So that you can't have tyranny. That's the theory. And I'm not sure this is necessarily always going to work, but that's the theory. Okay? Ambition should counteract ambition. And so here's an example of it. In the case of legislation, well, first, it requires both houses of Congress, the House and the Senate, to pass a bill. But then the bill has to be signed by the president or it doesn't become law. The president can veto it. Then it goes back to the Congress and they can override the veto. And then you have the courts that can declare laws unconstitutional. And you see, you get the idea. The executive branch tries to staff itself by the president making appointments. They have to be confirmed by the Senate. The president makes a treaty, has to be ratified by the Senate. You get the idea? So all these things are checks and balances where no branch can become too powerful. Now, in the House of Representatives and the Senate, in the legislature, we use the terms bicameralism and presentment. Bicameralism means two houses. That legislature must pass both houses by majority vote in exactly the same words. That's called bicameralism. Presentment has to be presented to the president. Veto is when the president says, I veto this, and sends it back. Override is where 2/3 of both houses overrule the president and pass the bill over the president's objection. What's the result of all this? It's hard to pass legislation. That's the idea. Frustrate tyranny. The federal judicial branch, well, they are given lifetime appointments that insulates them from the election process. They don't have to run for office, and they can't be gotten rid of except by impeachment, which is very, very hard to do. So neither branch can really do much about them. Now, federal judicial power is limited. We'll talk a whole week about that. They only do certain things. But they do have, the federal courts and in most state courts, do have the ability to void legislation that if they believe that it violates the Constitution. We call that judicial review. And this is a source of great controversy when the Supreme Court particularly, but any federal court could potentially do this. But to the Supreme Court, it really generates a lot of objections when they do it. And then let's talk about the amendment process. Okay, the Bill of Rights is actually a series of amendments. It is the first 10 amendments to the Constitution added in 1791 all at once. But since then, Since those first 10, which were done all at once, the Constitution has been amended only 17 additional times in all those years. So we have 27 amendments. Why so few? Oh, it's very hard to do. Now, it is possible that there could even be a constitutional convention, and we could have a new constitution. That can actually happen, and it's worth asking what that would look like. But here's the way that amendments can be proposed. They can come from Congress if 2/3 of both houses vote to do it, or they can come from a national constitutional convention. We haven't had one of those since 1787, but I'm just saying we could, right? And how do they get ratified? So normally our amendments are proposed by Congress. That's how we get them. And they either get ratified by 3/4 of all state legislatures or special state conventions, which we don't really do. The way it's always set up now, these days, is Congress drafts amendments, they pass by 2/3 of both houses, and then they have to be ratified by 3/4 of all state legislatures. Okay, that's really hard to do, very hard to do. I just call to your attention, there are other methods, particularly, just understand. It's possible that we could have another constitutional convention, and then that's the approach down below, a national convention. It could happen. It hasn't happened since 1787, but remember what they did last time? They took their existing constitution, which was the Articles of Confederation, and threw it in the garbage and started over. So anything's possible if you have a constitutional convention. Now, I want to go through the amendments and then we'll be done. We're going to cover civil rights and civil liberties at some length, but this is what you need to know now. Amendments 1 through 8 deal with individual rights and liberties. Amendment 9 says there may be other rights and liberties that we haven't written down yet. This is a very interesting amendment. Think about that. They're saying just because you don't have in writing a given amendment in the first 8 doesn't mean there aren't others. Isn't that interesting? And number 10, Amendment number 10, the 10th Amendment, says the states have the reserved powers. We've talked about that. Now, several amendments basically expand the electorate. The 14th, as we've talked about, 15th, the 19th, 23rd, 24th, those are all about expanding the electorate. Then we have other amendments that change the relationship between the elected officials and the electorate in various ways, mainly about the presidency. There are a number of issues in here about the presidency. And then there are the ones that limit the powers of government, 11, 13, 14, 16, etc. So, what I'm getting at here is that these amendments really didn't go into the heart of the Constitution and change it fundamentally. Understand that is possible. Anything can happen with a constitutional amendment.